So every now and then as a dean, you get to do things that you really are excited to do. And I am really excited to introduce this fabulous lecture that will be given by Bob Gordon, Professor Robert Gordon at Stanford Law School, though he's also been at Yale and a lot of other places. The historian of American law and lawyers whose work is so engaging that you want to read it because it's just delightful, as well as incisive and critical. He's known for his work on Holmes, his work on critical legal histories, an essay that I actually reread every year because it helps me have the map of the universe, and editor of Law, Society, and Law, Themes in Legal Sociology and Legal History of Lawrence M. Friedman. He's been, I think, an enormous force in the whole field of the study of law as a historical matter, in part playing official roles like president of the American Society for Legal History. His forthcoming publications include a book growing from many, many fabulous essays, Lawyers of the Republic, Taming the Past, Law in History and History in Law, and also The American Legal Profession. I will come back to him in a minute, but first I have to say something about the lecture series. The Biddle Lecture is a distinguished lecture at the law school that was authorized, enabled by a gift by Mrs. Frances Biddle, who established the fund as a memorial to her husband, who was a graduate of this school and Attorney General of the United States. And she said in the gift, "I hope that those selecting the individual lectures will keep in mind that civil liberties and civil rights were of particular concern to my husband, and thus are particularly appropriate subject areas for the lectures." And then she goes on to say, of course, I'm not specifying anything. You can do what you want. But that's by way of saying how terribly appropriate and wonderful it is that Bob Gordon has chosen as his topic to talk about Mark DeWolfe Howe, who was a great, great figure in precisely those fields. And so as I invite Bob Gordon up, I'm going to actually give him a memento of the occasion, which is the chair lecture, and he will give a lecture on a scholar activist in the 1950s and 60s. Let me also thank Tomiko Brown-Nagin and the program on law and history here, which is, I think, vibrant and excited as anyone about Bob Gordon's presence.
Okay, thank you very much for that introduction. You know, maybe if I'm given a couple more lifetimes, I can try to live up to it. Let me start by saying how this lecture came about. Last year, Professor Brown-Nagin invited me to give this lecture. I objected rather loudly that I wasn't the person to do this because I'm not a civil rights or a civil liberties lawyer, but a legal historian, and not even primarily a historian of civil rights or civil liberties. But Tomiko urged me to think about it, so I did, and came up with this idea for a talk about a local hero, Mark DeWolfe Howe. I had known Howe as an undergraduate. I sat in on his course in Anglo-American legal history, and his example is the main reason, in fact, that I went into legal history myself. I was on the Harvard Crimson, and we often turned to Howe for legal learning and advice. For example, in the spring of 1961, Harvard's president, Nathan Pusey, had refused permission for Pete Seeger to come to Harvard to talk and sing on the ground that he was under indictment for contempt of Congress, the House Un-American Activities Committee. We at the Crimson thought contempt of HUAC was a badge of honor rather than a disability, and we protested this restriction vigorously, and so did Howe, and he came down to our building to help us frame our objections to Harvard's decision, and I still can see him sitting at a typewriter in our newsroom, tapping out the draft of an editorial. Pusey relented under pressure, and Seeger came after all. We liked Howe's draft so much that we used big chunks of it in an editorial, and a year later it won a prize for student newspaper writing. we asked Howe what to do, and he laughed and he said, since the piece was the collective product of the Crimson editorial board, we could accept it on behalf of the board. Very lawyerly solution to this dilemma. In those years, whenever a liberal cause came up, Howe was somehow in the middle of it as a defender of victims of persecution or discrimination. He was very active politically as well, a Democratic Party ward committeeman for most of his life until he left the committee to support Elliot Richardson for Attorney General. I'll never forget his blistering speeches supporting Massachusetts Attorney General Eddie McCormick in his losing primary campaign against Teddy Kennedy for the Senate in 1962. This very fiery, eloquent public persona was all the more surprising because in private he was quiet, self-deprecating, rather reserved, but also charming and funny. So it was that when I was asked to talk about civil rights and civil liberties, the Mark Howe came to mind. I went through his papers in the law school's special collections to see if there was enough there for a talk. There was, and so I'm here with special thanks to the archivists at the law school, to Leslie Schoenfeld for reproducing the wonderful portrait of Howe by Polly Thayer, and especially to Marco Basili, who acted as my agent here to help me find more Howe materials after I returned to California. Some of you here were Howe's colleagues and knew him well, but many of you may never have heard of him. He's very much worth remembering. So, first, just the bare biographical facts. Mark DeWolfe Howe was born in 1906 into a remarkable literary family. His father and mother, Mark Antony DeWolfe Howe and Fanny Quincy Howe, were both well-known writers. His siblings, Quincy and Helen, were also writers. The younger Mark Howe, our Mark Howe, married the Irish playwright and actress Molly Manning, and the literary line continues with their daughters Susan Howe and Fanny Howe, both distinguished poets, novelists, and essayists. Graduated from Harvard College in 1928, Mark Howe, this is a little surprising to me, joined Paramount Pictures as a second assistant director and worked on pictures with Jimmy Durante and Fred Allen. He returned to attend Harvard Law School, where Professor Felix Frankfurter picked him to serve as one of Justice Holmes's last law clerks, and later as Holmes's authorized biographer. Howe's father, weirdly enough, had written the biography of Justice Holmes's father, the doctor and essayist Oliver Wendell Holmes Sr. Mark the Younger practiced with Hill and Barlow in Boston, then started law teaching at the University of Buffalo, which is where I started, and a grand school it is, to be sure. In the war, Howe served as Deputy Administrator of Wartime Administration in Sicily, was with the landing in southern France, where again he helped manage military administration. He was later assigned to the War Department. He participated in the Potsdam Conference, and he left as a full colonel with the Legion of Honor and the Distinguished Service Medal. He was appointed to the Harvard Law Faculty in 1946 and taught constitutional law, legal history, the law of church and state, and admiralty. He wrote on colonial legal history, law and religion, and constitutional law. Most of his life as a scholar was given over to Holmes, to editing Holmes's voluminous correspondence with the English judge Frederick Pollock and the English socialist Harold Laski, and with the Holmes biography. He finished 2 volumes, bringing Holmes through the Civil War and his years in Boston practice, and his lectures on the common law. I think there is universal agreement that these remain the best work ever done on Holmes, even though at least 5 full-length biographies, some of them excellent, have come out since. Howe really immersed himself in Holmes's Boston and legal milieu and his wide-ranging cosmopolitan intellectual influences, and the books are precisely and beautifully written. He was working on the 3rd volume on Holmes's years as a judge on the Massachusetts Supreme Court when he suddenly died of a heart attack in 1967 at the age of 60. So I'm going to divide this basically into 2 pieces, civil liberties and civil rights, which approximately correspond to Howe's activities in the 50s and early 60s, and then later in the mid 60s. First on the Red Scares, some background on this. For those who didn't live through it. In the 1950s, his political energies and extracurricular lawyering activities were mostly focused on trying to limit the damage inflicted by the domestic anti-communist crusades of the Cold War. Most historical accounts have come around to accepting the liberal view of the Red Scares as politically opportunistic exploitation of popular fears of communism, leading to grossly excessive inquests into and purges of suspected communist subversives and leftists generally. But they did not look that way to most people at the time. The rise of the Soviet Union as an expansionist power after World War II, the brutal Stalinist takeovers of Eastern European nations, the Soviet explosion of an atom bomb that broke the American nuclear monopoly, the Berlin blockade of 1948-49, the fall of China to Mao's army in 1949, the onset of the Korean War in 1950, really bewildered and terrified the most Americans and inspired the search for domestic scapegoats. Why had the communists been so successful? It must be because of American cooperation with or weakness in the face of the worldwide communist conspiracy. Most alarmingly, no one was immune from charges of subversion or treachery, not even those ferocious cold warriors, President Truman and Secretary Acheson, not even George C. Marshall, who had directed the Allied forces to victory, but had acquiesced in Mao's defeat of Chiang's nationalist Chinese, and certainly not Robert Oppenheimer, whose leadership of the Manhattan Project had been largely responsible, or so it was widely believed, in Japan's surrender in the war, but whose hesitations about developing a hydrogen bomb led to his symbolic trial and loss of his security clearance. And I remember very well at the time the academics thinking, my gosh, if they can do this to Oppenheimer, they can do it to anyone. There were unquestionably real Soviet spies stealing atomic secrets and real Soviet agents serving at many levels of government. So surely there must be many more, not only in government, but strategically scattered across American society. They have to be located and purged. This was an open invitation to opponents of liberal democratic policies and their supporters, including traditional Republican opponents of the New Deal and the expanding regulatory welfare state, Southern whites resisting racial justice, and politicians out to mobilize heartland and white ethnic voters, resentment against snobbish, overeducated Eastern elites, and to scapegoat liberals as agents or fellow travelers or dupes of communism. The prominent leaders of the purge were, of course, heads of legislative committees set up to investigate subversives, the House Un-American Activities Committee, Senate Internal Security Subcommittee headed by Pat McCarran and then Albert Jenner, Subcommittee on Investigations of the Permanent Committee on Government Operations headed by Joe McCarthy, and innumerable copycat committees, the Little HUACs set up in the states. In the background, feeding damaging information from informants or suspected subversives to the committees were private organizations specializing in compiling gossip. And also the FBI, although the FBI's role in leaking gossip to the committees was not known until fairly recently. Hoover was truly, and probably certifiably, had anybody dared to certify him, paranoid about the communist conspiracy, seeing it as centrally directed and having recruited millions of Americans, including the leaders of the civil rights movement and the student left and anti-Vietnam War protests to its cause. Notwithstanding the Communist Party USA's rather pathetic numbers of actual membership, doubled, rumor had it, by FBI infiltrators. The Red Honey Committees, of course, only had the power they did because the organizations that were most often accused of employing suspected subversives, in particular governments, labor organizations, civil rights and civil liberties organizations, state boards of regents, universities, and the entertainment industries, that is to say, the readouts of left-of-center intellectual, cultural, and political activism, were afraid of being labeled communist sympathizers themselves, and they undertook the dirty work of preemptively purging their ranks. President Truman led the field with his executive order establishing the Loyalty Security Programs of 1947, which resulted not only in the investigations of millions of federal government employees, but created the notorious Attorney General's list of subversive organizations. This listed not only the communist and fascist, but communist front organizations and those quote, consistently opposing the enactment of or advocating the repeal of laws and measures designed to strengthen and improve the security of the U.S. It was quite mysterious how a group got on the list, and almost impossible, despite some helpful court rulings, to get a group off it. There are parallels today in the criminalization of material assistance to any group the Secretary of State has designated a foreign terrorist organization. People belonging to the 50 or so organizations on the Attorney General's list could lose all federal benefits, such as military pensions and fair housing loans. More consequentially, the list went viral, functioning as a general blacklist justifying the firing of anyone in any job who ever belonged to one of its organizations. New York State piggybacked on the federal approach with its Feinberg Act, which empowered the State Board of Regents to draw up a list of subversive organizations, membership in which would be prima facie grounds for firing teachers. This was upheld against a challenge that it chilled free expression rights by the US Supreme Court in 1952. That's the Adler case, on the ground that although everyone has a right to express political views, no one has a constitutional right to be a teacher. The court reversed itself on this issue only much later in 1967. Other instruments for weeding out subversives were the omnipresent loyalty oaths, especially for teachers. In California, the most contentious jurisdiction, President Sproul of the University of California drafted on his own initiative a loyalty oath that a teacher was not a member of the Communist Party or under any oath or a party to any agreement or under any commitment that is in conflict with my obligations under this oath, which faculty had to take or be fired. Sproul took this action to forestall a constitutional amendment proposed by the California Un-American Activities Committee to put all of the state faculties under legislative supervision. The faculties rose in a revolt that lasted over a year, and as a result of which 26 faculty members were dismissed and 39 more resigned in protest. But the faculties were willing to assent to a resolution that no active member of the Communist Party could be a teacher in the system. Even private university administrators generally agreed this position, including the presidents of Harvard, Cornell, Stanford, and Yale. Many universities went further to make themselves the instruments of the Red Hunters through policies requiring dismissal of any faculty who refused to cooperate with federal or state investigating committees or who asserted Fifth Amendment privileges to such committees. Mark Howe was one of the first prominent academics to challenge the anti-subversion initiatives openly, making no secret of his view that they threatened free expression of ideas. And indeed were a greater danger to the Republic than any threat of domestic communism. As early as 1942, we find him objecting to, of all people, Attorney General Francis Biddle's request to the Postmaster General to censor the anti-Semitic radio priest, Father Coughlin's book called Social Justice by refusing to send it to the mails. Howe said, the suppression of social justice is just as an absurd and silly an act of censorship as anything done under the postal power in the last war, meaning World War I, of course. Apparently, everyone is frightened of the shadowy figure which he finds under his bed. The last time the reactionaries saw the forms of socialism and the Hun, this time the liberals see the form as fascism and Hitler. In 1952, he and two other Harvard professors, the lawyer-poet Archibald MacLeish and the historian Arthur Schlesinger Sr., spearheaded a civil liberties appeal, 20,000 letters asking for funds to defeat Senators Jenner and McCarthy. Jenner responded by calling them Harvard's pink boys and added, why they hate America, I don't know. Howe was in good company. Jenner had recently called General George C. Marshall a front man for traitors and a living lie. In January '53, Howe wrote President Conant of Harvard protesting what appears to have been the position Conant expressed to the faculty that universities should not defend their faculties from congressional investigations. Howe said, any attempt to dissociate the university from the effort of its faculty members to discover the answers to the pressing problems of our time and as citizens to express their opinion will imply that the university is indifferent to that effort. And in the minds of many will suggest the university is distressed that the effort has been made. One of the greatest dangers of our time is that the young teacher can no longer afford to be an energetic citizen. The risks which free expression today entails for the young teacher come no less, I suggest, from the obscene excesses of Senator McCarthy than from the cautious proprieties of the universities which, acting on the advice of public relations and legal counsel, have been persuaded, apparently, that the tranquility of an orthodox faculty is preferable to the ferment of dissent and questioning. And indeed, every university in the country had to confront the problem of what to do with faculty who defied the committees. As Ellen Schrecker has documented in detail, most were simply fired. Administrators struggled to develop general policy positions. One of the most influential sources was a document, as we'll see, a somewhat unfortunate document, produced by two of Howe's colleagues at Harvard Law School, Zechariah Chafee and Arthur Sutherland. Chafee was famous for his book on freedom of speech, which was the primary source of modern constitutional doctrine on free speech, and is generally credited with having persuaded Holmes to change his mind, to change his clear and present danger taste for suppression into a libertarian doctrine. Chafee himself was almost fired by Harvard in 1921 for challenging the sentence of Jacob Abrams and others to more than 20 years for publishing an anti-war pamphlet. He had to defend himself before a special committee of the Board of Overseers in what became known as the trial at the Harvard Club in Boston. Sutherland also had good libertarian credentials. He'd represented Philip Morrison of Cornell, a physicist who'd worked on the Manhattan Project, who was called before the Jenner Committee. Morrison was one of the first congressional witnesses to take the so-called diminished fifth against Sutherland's advice. That is, he did not assert Fifth Amendment privilege, candidly described his own political involvements, but refused to name names of others. He convinced a skeptical Cornell, that was against Sutherland's advice, by the way, he convinced the skeptical Cornell president and trustees that he was no danger and became one of the few non-cooperating witnesses to keep his academic job. These credentials, especially Chafee's, put a lot of authority behind a letter they wrote to the Crimson on January 7th, 1953. The letter said basically that witnesses owed a duty of candor to official investigators, no matter what they considered the committee's motives. The privilege of self-incrimination would not usually be available in response to questions about Communist Party membership, since the McCarran Act of 1950 said membership, as opposed to leadership, was not in itself a crime. Certainly the fact that disclosure, this is from the Sutherland-Chafee memo, certainly the fact that disclosure of present or past associations with the Communist Party will cause trouble for the witness with his church, his lodge, his union, his employer, or his university does not excuse him from answering questions about it when subpoenaed before a competent body. In some circumstances, they said the question might lead to other evidence of conduct that was criminal, and the privilege could then be invoked. But a witness who testifies about his own conduct waives the privilege and may not assert it on behalf of anyone else. A privileged refusal to testify is not an admission of guilt for the purposes of criminal prosecution. A refusal may mean only that the witness has innocently got into a situation where he is apparently, though not actually, guilty of a crime. But, fairly or not, the fact that he feels it necessary to refuse information to a government agency on the ground that it will tend to incriminate him inevitably casts a shadow on his reputation. Chafee later regretted writing this letter, but many university administrations used it to justify firing of Fifth Amendment witnesses. Then the issue assumed for Harvard a starkly concrete form when Wendell Furry, an associate professor of physics, was summoned before the House Un-American Activities Committee. Furry had joined the party in 1938 during the Popular Front years to support the Spanish loyalists' fight against fascism. He had worked at the National Radiation Laboratory during the war. He left the party in 1947. He refused to cooperate with the committee, wrote a press release denying that he was a communist, and invoked the Fifth Amendment. At the same time, Leon Kamin, a teaching fellow, and Helen Dean Markham, an untenured professor of medicine, were called before the Jenner Committee, denied that they were present members of the Communist Party, and took the Fifth Amendment in response to questions about past membership. Fortunately for them, Conant had left the university. Provost Paul Buck was running the university with a committee of the corporation. Furry's department supported him wholeheartedly and raised money to pay his legal fees. This was not typical behavior of colleagues at the time. Mark Howe became an unofficial advisor to the three recusants, especially to Furry. His job was to help make the case to the corporation that the three should not be fired. Unfortunately, we don't know exactly what passed between Howe and his clients and the corporation's fellows because the files in the main university archives are still closed. We do know that it worked. On May 20th, 1953, the corporation issued a carefully worded statement. The standard for firing was neglect of duty or grave misconduct. There was no neglect of duty, they found, no showing that communism had affected their teaching. The corporation officially deplored invocation of the Fifth. It was no excuse that the witness wanted to protect friends or thought the committee was abusing constitutional safeguards, or that he or she wanted to avoid prosecutions for perjury in case their testimony was later contradicted by others. That, by the way, was one of the great dangers of actually testifying, frankly. It was that the professional ex-communist informants would impeach your testimony by claiming that despite your denials, you actually had still been a member of the party, and then you could be prosecuted for perjury. Of course, if you refused to answer the questions, then you could be, without invoking the Fifth, you could be prosecuted for contempt. So if a member of the faculty invokes the Fifth, said the corporation, that's misconduct. But this is, I think, Howe's contribution here. But is it grave misconduct? Making their independent finding that none of the three was any longer a communist or allowed communism to influence their teaching, the corporation said no and allowed Furry to keep his tenured job and to remain Kamen and Markham until their terms ran out. Now, at this point, Nathan Pusey became Harvard's president. Pusey and Joe McCarthy had both lived in the town of Appleton, Wisconsin, where Pusey was president of Lawrence College. And while in Wisconsin, Pusey had co-chaired a committee to look into McCarthy's record to try to get him voted out of office. The investigator investigated. McCarthy decided he would expose Harvard as a harbor for communists and called a witness who said he knew Furry was a communist when employed by the radiation lab during the war. McCarthy then called Furry as a witness. Furry again invoked the Fifth. Then in January 1954, conducting a one-man televised hearing in Boston, supposedly on communism and defense plans, McCarthy called Furry again. He called Harvard a smelly mess and said of Pusey that while he professes a sincere dislike for communism, his hatred and contempt seem to be infinitely greater for those who effectively oppose communism and the communist threat. Pusey responded, "When McCarthy's remarks about me are translated, they mean only that I didn't vote for him." McCarthy revealed his motive for recalling Furry when he said that Pusey was not interested in whether there were communists on the Harvard faculty, so the Senate would hold witnesses in contempt to try to get them fired, which would be, McCarthy said, another way, perhaps, of getting rid of Mr. Pusey's Fifth Amendment communists. This time, on Howe's advice, Furry waived the Fifth, told McCarthy about his own involvement in the party and that he left it after the war, but he refused to name names of others. McCarthy predictably asked the full committee to hold Furry in criminal contempt. Howe lobbied senators to try to prevent that result, and then lobbied his contacts in the Justice Department to try to prevent them from prosecuting Furry. And he lobbied the ACLU to try to get them to take up Furry's and Kamen's cases. He said, "I cannot help feeling that the duty to become an informer may not extend to the naming of individuals before an audience of some 2 million persons." He also pointed out that the authority of this one-man committee to investigate was unclear, especially in the case of Kamen, who had never worked for the government. And 3 years later, indeed, the case against Furry was dismissed on the ground that the committee had exceeded its jurisdiction. Furry and Kamen were indicted for contempt, but had the charges against them dismissed by Judge Bailey Aldrich 3 years later. Helen Dean Markham had a similar ordeal. After the corporation refused to dismiss her, she was called back to the Jenner Committee, which put on a new witness, the professional ex-communist informer Herbert Philbrick, who wrote a book about his life in the party called, and as a member and then as a government informant called I Led 3 Lives, which was a big bestseller in the 50s. I heard all about this from my Uncle Frank, who was a young prosecutor of communists in the Smith Act cases. Used Herb Philbrick as his chief witness. Anyway, she said, Philbrick said he had heard from another communist who said Markham was secretary-treasurer of the Harvard branch of the party, and even if not a member, was subject to the discipline of the party. Harvard suspended her again and called for another hearing. Mark Howe pointed out to the corporation the difficulty of proving the negative proposition that Markham was not subject to party discipline. He also talked with Furry and Kamen. He said that Philbrick's hearsay informant might well have confused her status as an official in the local branch of the Association of Scientific Workers with a status as Communist Party official. Erwin Griswold, dean of the law school, helpfully weighed in with the observation that you could believe both Philbrick and Markham, because Philbrick's informant might have inferred Markham's Communist Party membership without knowing it. It was evidence, but not very good evidence. Hearsay and lack of first-hand knowledge. Their advocacy succeeded. The corporation decided that a finding establishing our most serious academic misfavor must be based on firmer evidence, and that a finding of grave misconduct would justifiably create a feeling of uncertainty on the part of all our faculty members, which would be far more damaging to the university than retaining Markham for the next 10 months of her term, at the end of which, as matters stand, she will not be reappointed. Markham wrote Howe, having support from you made me feel the whole fight was worth carrying on. Now, most non-cooperating witnesses lost their jobs and could not find new jobs because of the blacklist. The Harvard three were lucky. Furry kept his position. Kamen had a lot of trouble finding another job, but eventually found one at McGill in Canada, and eventually was hired as chair of the Princeton psychology department in the late 1960s. Helen Dean Markham had a very distinguished career in histochemistry at the Albert Einstein School of Medicine. One interesting result of the cases was that they converted Dean Griswold, formerly a supporter of the Chaffee-Sutherland approach to the Fifth Amendment, to the view that a witness's invoking the Fifth was not a reliable guide to the witness's guilt of anything, and certainly not to whether he was a communist. Griswold said we have to look carefully at the nature of the questions asked, which often are crude questions not adapted to elicit complex and subtle matters of belief, and also at the nature of the tribunal, especially one looking to embarrass for the sake of political gain. A little footnote here, Harvard and President Pusey were often congratulated for the courageous stand they took in defending their faculties from red hunters, and it's certainly true that in the Furry, Kamen, and Dean Markham cases, their record was relatively good, though not really outstanding when you consider that the non-tenured faculty were kept on only until their terms ended. Not until much later was it discovered that Dean McGeorge Bundy was screening prospective and current faculty suspected by the FBI to have ties with communism, and dismissing and turning away people who might cause trouble for the university. Now, in fairness to Harvard, it must be remembered that at the time, most people thought of the FBI as the reliable hunter of communist agents, in contrast to the demagogic legislative committees. And Bundy did give those suspected a chance to explain themselves, unlike many universities that just simply gave into the blacklist. It was also revealed later that Hoover's FDI not only supplied the committees with damaging gossip, but also operated its own blacklist, smearing academics by sending anonymous letters to college administrators. Howe also played a key part in analyzing the various loyalty oaths that university faculty and students were asked to take over the years. He was instrumental in persuading Harvard to reject government money under the National Defense Education Act in 1959. On the ground that the act required applicants to sign an affidavit that says, I do not believe in and am not a member of and do not support any organization that believes in or teaches the overthrow of the United States government by force or violence or by any illegal or unconstitutional methods. The sticking point in that oath is obviously the believes in part of the affidavit. You know, what does it mean? What kinds of thought does it prescribe? Violation of the oath carried criminal penalties. Howe thought it especially dangerous because it would lead students to be afraid of unorthodoxy, to be afraid to join any organization that somebody someday would take to be subversive. And of course he was right, that kind of caution was generally in season. 2 years later, the act was amended to drop the affidavit, and this time Howe advised the Faculty of Arts and Sciences that it was now safe to take the money. It showed the kind of confidence that faculty had in Howe's judgment that they took his advice on both occasions. Periodically, he was asked for his opinion on another oath, that one required of all Massachusetts teachers, including professors at private universities like Harvard. That oath was the remnant of an earlier Red Scare following World War I, and an anti-communist crusade carried out by Irish Catholic politicians in the 1930s against godless liberals such as Harvard professors. Liberals tried repeatedly and failed to get it repealed, but they did get it amended in 1938. Now, in 1959, Dean Bundy came to Howe to ask a favor. The great literary critic Edmund Wilson had been offered an appointment to spend a visiting year at Harvard, but Wilson had balked at taking the teacher's oath. Bundy asked Howe to see if he could overcome this obstacle. Howe wrote Wilson to say, "I fully understand the indignation you have felt on discovering that the Commonwealth extracts this degrading promise from teachers. Time and experience have done something to persuade me, however, that the present law is a tolerable piece of foolishness." He explained that that was because the 1938 amendment provides that nothing shall be construed to interfere with freedom of thought and speech, which, said Howe, has converted the oath, quote, from an insulting threat into a largely innocuous insistence upon ritual. Also, he said, some Supreme Court decisions since seem to have recognized academic freedom as a right specifically protected by the courts, and the experience of the McCarthy years suggested the oath wasn't much use to Commonwealth officials who went after Harvard faculty. The little McCarthys of Beacon Hill, Howe said, came to see, I believe, that they could not successfully attack such a strong opponent as Harvard with an empty water pistol like the Massachusetts Oath. Howe added, "There are real dangers, I know, in calling bad laws silly laws. The Massachusetts Teacher's Oath law is both bad and silly." But he thought changes in constitutional doctrine and text made it less bad than it was, and I can testify that many teachers of liberal, even courageously liberal views have been able to live honorably and teach honestly with the statute on the books. Wilson was persuaded by this analysis, waived his objection, and while at Harvard wrote his great work on the Civil War, Patriotic Gore, which had a final chapter on Holmes, owing much to Howe's work on Holmes. Eventually, Howe worked on the case brought by another recusant, Joseph Pedlowski of MIT, and just after his death, the Massachusetts Supreme Court invalidated the oath in a brief opinion, calling it unconstitutionally vague. Now, the other civil liberties issues in which Howe took an active interest were those having to do with establishment of religion and religious freedom. This field was one of Howe's specialties as a legal historian, which led him to some views of the religion clauses that were, from the viewpoint of many secular liberals of his time, somewhat unorthodox. He wrote an elegant little book called The Garden in the Wilderness in 1965, which explored the Revolution-era protests of Baptists and other dissenters, and argued that their political agitation for disestablishment owed less to the desire to keep religion and sectarian strife out of politics than to keep politics, the wilderness of the world, from corrupting the garden of conscience and religious observance. In arguments with Leo Pfeffer, whose theory of the original meaning of the religion clauses found its way into Supreme Court doctrine, Howe doubted that history compelled any single reading of the Establishment Clause. Some states, like Virginia, adopted the Jeffersonian, and for different reasons, the Baptist view of separation, and others, like Massachusetts, understood religious worship to be both a right and a duty, preferred Protestant to non-Protestant religions and non-believers, made blasphemy a crime, promoted religious instruction in public schools, and generally thought the state had a responsibility to lead its citizens to preserve good order and morality to the truths of Protestant Christianity. The First Amendment's Establishment Clause declared the principle that the nation's authorities, quoting from Howe, should never be brought to bear on matters were not of national concern. It was a principle of federalism, not a program for disestablishment in the states. In recent decades, legal historians have largely come around to Howe's version of church-state relations at the founding, but Howe was not any kind of originalist. He not only thought that views of church-state relations at the founding were too diverse to inform current constitutional doctrine, but also that in the much more religiously plural society that America had become since, the older doctrines were patently outdated. He reproached Pfeffer for assuming a unity of Protestant thought from the end of the 18th century until the 1920s that in fact didn't exist. Howe's main quarrels with liberal separatists were over minor matters. He didn't see how the Establishment Clause as a principle of federalism could be incorporated against the states through the 14th Amendment so as to prohibit religious observances that didn't interfere with anyone's liberty, like the Regent's Prayer condemned in Engel and Vitale. He saw no problem with state aid to parochial schools to support secular programs in those schools. But he also disputed those who supposed that religious liberty was entitled to preference over other forms of liberty. He said, if all our civil liberties come from God, as the religious libertarians claim, then all partake of the divine. Towards the end of his life, he was much preoccupied with how to reconcile his position on aid for secular purposes to religious schools with the southern states' policies of state aid to the Christian academies created to avoid segregation. Howe was shocked to learn from a Crimson story of March 28, 1958, that Harvard had denied permission to a non-Christian couple to be married in Memorial Church. He wrote President Pusey saying that if the story is true, I think the policy is so profoundly mistaken that each of us who is concerned with the good name of the university is bound in conscience to protest the decision and to urge that the matter be reconsidered. Pusey, who was extremely stubborn on this issue, responded saying, Harvard's official policy on this matter is the same as it was when we were in college. Although the church is non-denominational, it has always been thought of as a place for Christian worship. This is abundantly evident in its architecture, in its symbolism, and in the words of its service of dedication. We have always had to regretfully deny applications for private non-Christian services. Many other faculty protested, including the great historian of Puritanism, Perry Miller, who called Nathan Pusey an Erastian heretic. And a delegation of distinguished professors, including Howe, visited Pusey to try to get him to change his mind. Howe drafted language that would affirm the church's traditionally Christian character, but open it to non-Christian services like weddings. Pusey did not want to change his mind, but some weeks later the corporation overruled him and modified the policy. Years later, writing to Kingman Brewster on the issue of aid to parochial schools, Howe said, I don't myself have such fear of Catholic power and plans as to be much concerned with the entering wedge analysis. But I take it you must be mildly watchful of the suspicion that Bill Buckley now calls the tune at Yale. Doug Buckley had written this book, God and Man at Yale, which complained that that Yale was going unspeakably and undesirably secular. Luckily, we don't have to worry about that danger up here. The power behind our throne has the best credentials, and when Nate speaks, it's not his own or Buckley's voice that we hear. It's bigger, it's better, it's his. Yours intolerant sacrilege. Howe had other quarrels with fellow liberals over conscience-based objections to the draft. He was a ferocious opponent of the Vietnam War and joined with others in a successful effort to get the Justice Department to tell the Selective Service that it could not punish war protesters by removing their student deferments to make them eligible for the draft. But he did not support the ACLU's bid to exempt all objectors who claimed any conscientious basis for their objection, including their dislike for this particular war. He also disapproved of student deferments, which effectively exempted the upper strata of society from military service, and he supported movements to replace them with a lottery. Universal exposure to the draft, he believed, as many others did, might be a brake on plunging the country into reckless wars. Civil rights. Now, one of Mark Howe's early civil rights causes, though there's no reason to suppose he thought of it that way, was the admission of women to this law school. Shortly after he joined the law faculty in 1946, Dean Griswold asked him to review Harvard's long-standing policy of not admitting women. Griswold describes Howe in his memoirs as coming from a fine old family and having a fine personality. Both are very true. After opposition, some of it strong, Howe's views prevailed on the faculty, and the first class of women, all 13 of them, were admitted in 1950. Howe was later to become intensively engaged with the cause of black civil rights in the late 50s and 60s. One of the first records of his views of the cause comes from an account of a debate with Arthur Sutherland in 1953 over whether the Supreme Court should act to abolish legal segregation in the South. Howe, and I must admit this surprised me at first, took the negative. Both agreed that segregation was immoral and should be ended, and that the court had the legal authority to declare it unlawful. But Howe believed such a decision would provoke strenuous resistance, and that a more promising approach would be to work on rigorous court enforcement of the equality prong of separate but equal. Under such a regime, the hope was that blacks would progress economically, the states would find it too costly to finance real equality, and segregation would gradually disappear. This was, of course, one of the positions taken within the NAACP leadership itself, and it was founded on deep pessimism about whether the white South would accept the overruling of Plessy. When Plessy was overruled in the Brown decision the following year, Howe praised the court for taking action, but thought it might be 10 years or more before integration was realized. He was on the panel which he appeared, which included Paul Freund and one other person I don't offhand remember who. He was by far the most pessimistic about the likelihood of compliance, and it turns out the most prescient. Howe devoted much of his extracurricular energy in the years following the Brown case advising Congress officials in Congress and the Justice Department on civil rights legislation and enforcement strategies, and trying to think through the problem of the scope and limits of federal jurisdiction under the Reconstruction Amendments and Civil Rights Acts. His memos and letters on this subject are too bulky to recount in detail. To characterize them briefly, they have the very Mark Howish qualities of adventurously broad theories of federal jurisdiction, accompanied by lawyerly caution about overreaching. He was particularly insistent on the point that the federal government could do much more to protect civil rights activists. In the long period when the Justice Department was taking the position that law enforcement and keeping order in the South were state and local responsibilities, and until or unless there were actual violations of federal law, as Burke Marshall, Assistant Attorney General, put it, there is nothing to do unless something happens. John Doerr of the Civil Rights Division met with the volunteers at the beginning of Freedom Summer in 1964 to tell them the federal government could not protect them. J. Edgar Hoover himself came to open an FBI office in Jackson, Mississippi in July '64, but gave a press conference to make it clear that protecting civil rights workers was the job of the local police, not the Bureau. This passive policy was getting demonstrators and protesters beaten by the police and sometimes murdered by private gangs. These young activists, Howe and his colleagues wrote to Burke Marshall in 1963, are a national asset, doing what the federal government can't do, feeling abandoned now that the government is not coming to their aid. Justice Department needs to do more to sustain the morale of this cadre of young leaders. Even today, with all we know about the history of the civil rights movement, it's still a shock to be re-immersed in contemporary accounts of how all of the official elements and civic leadership of Southern society collaborated to harass and arrest and beat and jail not only the protesters, but elderly, respectable black citizens trying to register to vote, to deprive them and their families of their jobs, of livelihoods and retaliation, and to give immunity to the thugs and gangs who attacked them and burned their houses down. The entire legal leadership of the most resistant states, from the governor and attorney general down to local prosecutors, the judiciaries from the state Supreme Courts down to the local JPs, worked together to insult, humiliate, fine, and jail activists brought into court on invented criminal charges like breach of the peace or driving without a state license or loitering or obstructing the highway. Even many of the federal judges, especially those like the notorious William Harold Cox of the Southern District of Mississippi, appointed by John Kennedy to appeal the Dixiecrat wing of the party after the 1960 election, often sided with local law enforcement. Almost no members of the Southern Bar were willing to defend civil rights workers. Instead, they spent their energies trying to get investigating committees and officials and bar associations to discipline or disbar or expel from the South the Northern lawyers who were trying to help the movement. In late 1963, the Student Nonviolent Coordinating Committee, SNCC, after a long and heated debate, voted to invite white college student volunteers from the North to join their sit-in and voter registration drives in Mississippi. Purpose was clear. Where elite white college kids went, so did FBI agents to protect them and generally favorable press coverage. If they too were harassed and beaten, as they certainly would be, their plight might finally attract federal intervention. Bob Moses, one of the SNCC leaders, said, "These students bring the rest of the country with them. They're from good schools and their parents are influential. The interest of the country is awakened, and when that happens, the government responds to that issue." James Foreman recalled, "We made a conscious attempt to recruit from some of the Ivy League schools. You know, a lot of us knew what we were up against, so that we were in fact trying to consciously recruit a counterpower elite." An added benefit was that SNCC was broke and the volunteers could pay their own way. Eventually, about 1,000 volunteers went to Mississippi in the summer of 1964. This was Freedom Summer, a pivot point in the history of the civil rights movement. As expected, the influx of the volunteers focused a lot of publicity on the movement and on conditions in Mississippi. It also gave the activists some protection against official and unofficial violence, but not much. Goodman, Schwerner, and Cheney were murdered that summer, thousands of others arrested and beaten in jail. 37 churches and 30 black homes were bombed or burned. In July, the Civil Rights Act of 1964 was enacted. In August, President Johnson, fearing the loss of the white South in the coming presidential election, refused to seat the insurgent movement's delegates. These were Fannie Lou Hamer's delegates of the Mississippi Freedom Democratic Party at the Democratic National Convention, in place of the regular segregated party delegates. Comfortably reelected, Johnson tried to make up for this by pushing through the Voting Rights Act of 1965. The convention fight, however, had been a bitter one, and it was one of the factors that eventually led SNCC to exclude whites from its movement. Returning to the North, many of them, like Mario Savio, provided the leadership for the student left in anti-Vietnam War protests. To Freedom Summer, along with the volunteers, the FBI, and the press, came lawyers. Now, there were 4 different lawyers' organizations working in Mississippi in '64 and '65. The oldest of them was the NAACP's Inc. Fund, also the National Lawyers Guild, the Lawyers Committee for Civil Rights Under Law, which is a group which had been formed as a result of an appeal by President Kennedy to the elite bar in 1963, and another new committee, the Lawyers Constitutional Defense Committee, LCDC, founded in 1964 by Carl Rachlin, a former general counsel of CORE. LCDC was eventually to be absorbed into the ACLU. Rachlin saw a need and an opportunity for a new organization. The Inc. Fund was largely occupied with bringing strategic impact litigation involving long-term planning. For the civil rights movement's activists, sit-ins, street protests and marches, pickets, and voting registration campaigns, a different role opened up for lawyers as the on-the-spot protectors and defenders of the movement's activists, enjoining the denial of parade permits, accompanying people trying to register, defending them against innumerable trumped-up charges of speeding, loitering, assault, trespass, breach of the peace, and the like, and handling appeals and removals from the inevitable defeats in state and local courts, and getting people out of jail. The activists were constantly on the move. Their lawyers had to be as well. The Lawyers Guild was already supplying some lawyers for this task, but the Guild had a reputation for being tainted by communist associations, and many lawyers, like the Inc. Funds, wanted nothing to do with it, despite their common interests. The Lawyers Committee had the opposite reputation of being too stuffy and cautious to be of much help to the movement. In its early years, it specialized in defending arrested clergymen from the National Council of Churches, and wasted years of effort on a futile project of trying to persuade elite lawyers in the Southern Bar to join its efforts to bring about a peaceful transition to racial integration and to dampen racial violence. And as soon as lawyers for any of these groups took to the field, their differences, however, tended to vanish in the overwhelmingly pace and volume of work. The first year of LCDC's Operation Freedom Summer in '64 were chaotic. They depended on volunteer lawyers who would fly in for a couple of weeks, file cases and motions, and then disappear. For 1965, LCDC directed its chief staff counsel, Alvin J. Bronstein, to provide a stable presence on the scene by staffing an office in Jackson, Mississippi, to serve as headquarters for Mississippi, Alabama, and Louisiana operations. Bronstein was and is a lawyer of formidable intellect, courage, and tenacity. He was later to become director of the ACLU's National Prison Project for 23 years. LCDC called a planning meeting for its volunteers at NYU in the fall of 1964. And as Bronstein and Henry Schwartzel tell the story, in the audience, uninvited and unintrusive, was Mark Howe. He had come on his own to learn. By letter a day later, he offered his services to LCDC as a volunteer lawyer, describing himself as a member of the Massachusetts Bar with some vacation time available in the summer and without any trial experience that counts within the last 25 years. He had serious doubts, quote him further, on whether an old horse can be taken from the academic stable and made an effective warrior on the battlefield. Bronstein had no such doubts and signed him up immediately to go to the Jackson field office. On his first day in Mississippi, Howe was sent up to Benton County, the far north of the state, to defend a libel suit brought against SNCC civil rights workers and their supporters in the Benton County Citizens Club. That sounds like a group of white supremacists, but it wasn't. It was a group of civil rights activists. It was a group of black parents organized to improve conditions in local schools. The SNCC and the club had aroused the anger of the principal of the local black school, W.B. Foster, who had refused to lobby for more resources for the school and who retaliated against teachers who supported civil rights and the club. Foster got a white SNCC volunteer, Aviva Futorian, arrested for supporting the movement, and the club then organized a boycott of the school. The county school board tried to retaliate by firing 4 teachers and bus drivers, and the club's newspaper, the Benton County Freedom Train, published cartoons of Principal Foster and editorials calling him a puppet, a dummy, and an Uncle Tom. Foster, the principal, sued Futorian and others for defamation, asking for $650,000. Trial began as Mark Howe and another Boston lawyer, John Saltonstall, arrived on the scene to defend the libel suit. Opposing attorneys in the case demonstrated Southern hospitality by inviting them to lunch, and then one of them said, after all, I could have you killed. We have plenty of Klansmen around here, and all I need to do is to give the word, and I don't run the county that way. In the bench trial, the judge, not surprisingly, found that Foster had been libeled and awarded him $60,000. On appeal, the case was first remanded because the court had not found malice in the libel. On remand, the trial judge fixed that problem by saying the efforts of defendants to remove Foster showed malice. On the next appeal, with Saltonstall and Howe on the brief, the Mississippi Supreme Court in 1967 finally reversed on the authority of New York Times and Sullivan. For the rest of the summer, Howe worked in the Jackson office writing memoranda, motions, and briefs. Then, after returning to Harvard, he sent a steady stream of briefs and memos and strategy papers to LCDC lawyers, trying cases and arguing appeals. He became a director of the LCDC, a tireless fundraiser on its behalf, trying to convince a skeptical Jack Greenberg of the Inc. Fund that LCDC deserved its support more than the Gentlemanly Lawyers Committee, and brokering its eventual adoption by the ACLU. Howe expressed to Greenberg his surprise that the Inc. Fund saw more promise in the Lawyers Committee, a venture governed by the establishment, than in one governed by those whose commitments are to radical and far-reaching changes in the social structure of America. Like all who joined that struggle, Howe was obviously deeply moved and somewhat further radicalized by his experience. The earlier, more cautious Howe, who had doubted the wisdom of federal intervention in the South, was long gone. He circulated a petition in 1965 asking the Speaker of the House to recognize the representatives elected by the Mississippi Freedom Democratic Party. For some time, he had worried that the 14th Amendment was an inadequate basis on which to rest civil rights legislation because it required state action. The political leaders of the South, he said, have repeatedly assured us that no stone, no petal of magnolia will go unturned in their efforts to frustrate the nation's objectives. The state's response to 14th Amendment-based litigation and legislative response has been to shift discrimination to private choice, hopeful, if not confident, that discrimination will flourish as luxuriantly on private prejudice as it has on public law. And after the Civil Rights Acts of 64 and 65 were enacted, he testified before Congress urging more drastic legislation, especially directed at private discrimination in housing, urging that it be based on the 13th Amendment, as of course eventually was in the Jones and Alfred Mayer case, to solve the problem of having to find state action. The 13th Amendment was underused as a basis for civil rights legislation, he suggested, because of the tendency to assume the 13th Amendment became a dead letter with the more sweeping assurances of the 14th. The most unfortunate aspect of that assumption lies in its suggestion that the power given to Congress in the second section of the 13th Amendment, the power that is to take action against racially motivated private conduct that revives the outlawed racial caste system, has been extinguished. This false assumption has led us to suppose that all civil rights legislation must find its justification in the 14th Amendment and must therefore be directed towards the control of state action. Surely it would be a tragic irony if the 89th Congress in 1966 were to endorse by inaction the political timidities and constitutional errors of Andrew Johnson, timidities and errors which the 39th Congress renounced a century ago. In an essay in a volume called Civil Rights, the Constitution, and the Courts, published just after his death, Howe's essay begins, "The Southerlies are still blowing. They have told us of the killing of Medgar Evers, William Moore, James Reeb, Andrew Goodman, James Chaney, Michael Schwerner, Lemuel Penn, Viola Liuzzo, and Jonathan Daniels. They brought us the names of others, but those others we have forgotten because they were merely 4 little children at church in Birmingham. The breezes from the South have told us these ugly tales, but they have not spoken of convictions of the guilty. They tell us instead of murders, acquittals, mistrials, and local pride." Fannie Howe, his daughter, just a few years ago, in a wonderfully touching and interesting memoir of her father, describes him in this period, thus his increasingly desolate view of existence, as something without an ultimate cause or goal, helped him in his work, since human nature showed no signs of improvement despite the warnings of the law or in the churches. He saw a contradiction in power and depth in the poor and couldn't stand religiosity. He even remarked that perhaps atheists needed the protection of the law more than religions did, given the attacks on communists as atheists, the upsurge in religious fundamentalism, and casual dismissal of the First Amendment. She goes on, his involvement in the civil rights movement, the third great all-consuming interest of his life after the war and McCarthy, galvanized all that he had learned through the first two. He might as well have put on his uniform and picked up his briefcase to enter a battlefield again. He taught and acted as a legal consultant, went south and worked in north on the busing issues. The spirit of the Constitution was, he believed, transparent, but race and religion were two recurrent dilemmas in the nation for a reason. They could be used to bring down the revolutionary nature of that spirit. Now I know that those who will restore the country's heart and direction will be those who have benefited least from the years since 1968. My father worked for social justice and was eviscerated, I think. When he died, when he died, he had had enough. This has been, it's coming in right on time. This has been a brief tour of some of the highlights of Mark Howe's engagement with civil rights and civil liberties. Much more could be said, and I hope one day will be said. I'm not going to pretend, and Howe himself would be the last person to claim, that he was a major player in these great events and a major contributor to the great causes in which he took a part. He was not. Certainly he did much more than most legal academics, but some legal academics, like Tommy Emerson of Yale and Tony Amsterdam at Penn, did a lot more than he. Howe had a demanding day job as a constitutional law professor, a legal historian of the colonial period on law and religion, and a biography of Holmes. In fact, writing the Holmes biography was such hard work that his widow thought it killed him well before his time. Marginal though he may have been, Howe was an important figure in the civil, religious, and civil rights struggles. He filled an honorable role in our national culture, the patrician as radical, like his abolitionist forebears and his colleague Zechariah Chafee. The patrician's privileged status helps to confer legitimacy on radical movements. If he supports them, how radical can they be? And gives some protection to the less privileged, who are usually the movement's spearheads and shock troops. This was, in fact, the role that Howe's subject, Justice Holmes, played in the lives of the young liberals and socialists, often Jewish, like Felix Frankfurter and Harold Lasky, who became his acolytes. The old justice's friendship and his example helped shelter them from abuse by allowing them to claim him as their mentor and helping them expand the range of acceptable speech and action. Big difference between Howe and Holmes, of course, is that Holmes thought his protégés' upward and onward progressive ideals to be, as he often expressed it, drool. Whereas Howe completely believed in the causes of the people he inspired and sponsored, and his identification with them was not out of noblesse oblige, but of comradeship. And this is in part personal testimony. Not only did he encourage and legitimate the already engaged, but he inspired the disengaged to come off the fence and join his causes. He might sometimes be wrong, but you knew he'd thought his position through carefully. He was eloquent, but never demagogic. He always looked for compromise, but never weaseled or trimmed against strong prevailing winds. I've told you a lot about what Mark Howe said and did, but I haven't really managed to convey to you the warmth and strength of his personality. His speech was measured, polite, and precise, but touched with fire. When he spoke for a cause, you could almost hear the sound of trumpets behind him. It was that inspiring. He had a soldier's directness and erect bearing. He seemed to radiate the deepest gravity, and yet he could stop in the middle of a passionate call to arms if something funny occurred to him and break out in that famous smile. Really a man of extraordinary charm and depth of feeling, as well as intellect and courage. Thank you. Questions, comments? Yeah, there you go.
So can you speak a little bit about how his colleagues reacted to his activism in the civil rights movement during the 1960s?
Dean Griswold used to refer to Mark Howe as the House Radical. And so I think it's fair to say that he was on what was then, since new dimensions had yet to be created in that domain, the far left of the faculty. He did have support. A lot of these letters and petitions are co-signed by colleagues of his. His colleague John Mansfield went south with him in 1965. The letters on the scope of the civil rights amendments and petitions are usually co-signed by Paul Freund, and some of these names may surprise you somewhat. Paul Bator, Charles Freed, who were all liberal, indeed left liberal professors at that time in their careers. So I'd say the law faculty, by and large, by that time, having been restaffed by ex-New Dealers after the war, was no longer the very conservative faculty that it had been in the years of Roscoe Pound, when Frankfurter and Landis were its far left. So I think on the whole, the law faculty was pretty good on these subjects. What distinguished, at least many of its members were, what distinguished Howe generally was that he was willing to get out in front and in public and say what he thought. He was, in a time, particularly the McCarthy period, where people were really keeping their heads down to avoid being tainted by association with Fifth Amendment communists, that he was very outspoken. Now, it's true, Howe was protected by his tenure, his standing as a constitutional scholar, and his war record from being accused. But a lot of people who had those protections kept their mouths shut during that period. So and in some ways, his public activities, I think are more impressive for that reason. He's kind of a funny guy, because you always got the impression that he was a little reluctant to put himself out publicly. But the fact was that in that period, he was just like everywhere. He was at every like rally or memorial or protest, and he would head fundraising campaigns and petition campaigns, he was on many committees having to do with civil rights and civil liberties. So obviously completely identified with that cause. The Teddy Kennedy thing was kind of funny because at the time that Teddy Kennedy challenged Eddie McCormick, the Massachusetts Attorney General, in that primary, he was seen completely as a spoiled and not very bright child of privilege. I remember one of my Crimson colleagues wrote a very funny editorial called "My Poll." Said, I took a completely representative sample of 11 Harvard students and asked them, and faculty, and asked them, which candidate do you hate? This was in the 1962 Senate race, and they all responded, Teddy. That was the Senate race in which Teddy Kennedy, the president's brother, was running against George Cabot Lodge, Senator Cabot Lodge's grandson and son, and H. Stewart Hughes, the grandson of Chief Justice Charles Evans Hughes, who was a member of the Harvard faculty. And in Massachusetts, needless to say, Kennedy won by a large margin. And Kennedy, of course, eventually, the irony is that Kennedy then becomes the great left liberal legislator of the Senate, not the useless, not the useless, sort of idle sprig of the rich layabout that he was portrayed to be. Jay. This is Jay Featherstone.
I'm interested in the how saw either connections or no connections between the civil rights movement and the anti-war movement.
He did see connections. He was, by the way, very active in both movements. I haven't said much of his anti-war activities because they were really just beginning at the time that at the time that he died. He saw them, I think, in many of the same ways that Martin Luther King saw them, as to say that these imperial wars were draining the attention and funds of the country away from the war on poverty and away from the struggle for racial justice, and that they were being fought by the least privileged people in society. So that's one of the things that accounted, I think, for his position on the draft. He really thought it was just outrageous to exempt the upper class from participating in wars that they had started. He was very, very, very passionate on that subject. So I'd say his and King's view of this were pretty parallel. He thought that there was a lot to do, and he was The Fanny Howe's picture of him at that period of life is a bleaker picture than how I remembered. But of course, she knew him very, very well indeed. So I accept that portrayal. And there's almost an uncanny resemblance between the Holmes who emerged from the Civil War and the Howe that is pictured in Fanny Howe's memoir. Duncan.
What about in the battles about federal jurisdiction, the way I vaguely remember it, there was a real kind of confrontation with the Hardin-Wexler larger federal court's vision,
Yes.
and the arguments in favor of a much heavier level of intervention.
Yes.
Was Howe in any kind of dialogue or oppositional relationship to part and parts of
You know, I'd love to know the answer to that, and it would probably I can't find it in House papers. It would have to be searched in Hardin-Wexler's. The Hardin-Wexler view was the prevailing view in Bobby Kennedy's Justice Department at the time, very strongly, and we know that Howe objected strenuously to that view. You know, he believed that Civil War amendments had given not only Congress but the federal courts a very wide mandate to eliminate segregation to eliminate segregation in the South. And here, I mean, Howe's sort of interesting as a legal historian for the way he kind of used history in present argument, and he used it in the way I think. Most of us do. That is to say, most of the time he was in the historian persona saying, we really can't, directly apply these historical lessons to the present day. About the 14th Amendment, can we say that its sponsors, wanted to end segregated education? He said, well, some of them really did, and some of them really didn't. And it's hard to draw conclusions, from the intentions of the sponsors. But on the other hand, he said if you look at the language of the amendments in their text, they authorize a very sweeping federal jurisdiction to control racial abuses in the South. Not only the 14th Amendment, but also the 13th and the Civil Rights Act of 1866, which he read very, very broadly. It's an interesting question. There must have been lots of dialogue on these issues with Hardin-Wexler, who were into dialogue, as we know. And maybe generously funded further research will help to resolve this question.